when you went to museums, you would have noticed that not enough number of people, enough number of museums, do not have very strong lighting, and it's only because these works of arts, when they are exposed to artificial light for a very long period of time, their quality fades, their color fades. So which is why then this company in Netherlands thought that can we recreate an artwork which looks like it has been created by now dead Rembrandt. So what they did was that they started looking at all the paintings, and they started studying the works of Rembrandt so that they could create an extensive database which includes deep learning algorithm. So what they were looking at all the paintings and all the works of Rembrandt. They were trying to see how many of these works were males, how many of them were females. They were trying to study the gender, which was sort of constant amongst all Rembrandt's work. They were trying to see different things, like in a typical Rembrandt work, what was the direction of the face, so that they could create a painting which looked very similar, which would remind you of Rembrandt work. And in the next step, what they did, that they started determining the subject by extracting various features through algorithms. So and then they started generating these features. So for example, most works of Rembrandt surrounded around a white Caucasian male. The sort of the structure of the nose, the features like the lips, the gap between the eyes, all of these things were fed into that AI system. That if there are, say, 10 Rembrandt paintings, then these are the features in all these 10 Rembrandt paintings. And this was done through statistical analysis. For those of you who may not be aware, statistical analysis is essentially the science of collecting and exploring very large amounts of data so that you can study them and you can discover underlying patterns and trends in it. And Stesco analysis was also used to extract these features, which essentially made a Rembrandt a Rembrandt. Uh, Ma'am, we are live on YouTube right now, so students will be interacting through that live chat. You can take questions now if you like. We will convey it to you. Yeah, I'm happy to take questions irrespective. I mean, if anyone has a question, just feel free to stop me then and there. Put your question in the chat box, and I'm happy to answer. Anyway, it's a very short 1 hour session, so it would be nice if I could also hear. But yes, as I will, and I don't, and I'm not looking at YouTube right now. So Hiteshi, I'm depending on you to relay those questions to me. Thank you so much for your coordination. So I was talking about statistical analysis, and I was talking about Stesco analysis, right? And I was looking, and I was telling you the steps in which all these works of Rembrandt were being studied, were being collected, so that all that input could be used. These are all actually pictures which are in GIF formats. So they were supposed to move, but they are not moving on this particular platform. But I would urge you to go on YouTube and to Google Rembrandt, and you will come across a very short, very interesting 10-12 minute video which explains all of this process. And mind you, it's very interesting. So if you're interested, just look it up, or I'm happy to share the YouTube link at the end of the lecture. And once that was done, once everything was collected, it was brought to life. A height map was analyzed, and again this GIF was supposed to move, where it would show you that the paintings layers were studied, and people who paint, anyone who has an interest in painting in this particular class, would understand that when you do layer painting, or when you do oil painting, or when you do knife painting, to add depth to the painting, you add several layers so that, say, the nose stand out, the high parts of the face stand out. And all of these things were analyzed in previous Rembrandt's artworks. And then they were all used to bring out layers by a 3D printer. using special UV ink so that that height and texture of the painting could be made out. And I mean, again, the picture was supposed to move, but you won't be able to see the final output. So, like I said, one of them is AI generated, and the other two are made by Rembrandt. Now that I have given you some more context, which one do you think is AI generated, and which one do you think is Rembrandt generated, made by Rembrandt? Anyone? One. How many of you think number one is AI generated, or how many of you think number two is AI generated? Number so just to let you all know, number two, the one which you see in the middle, is generated by AI, and the other two, number one and number three, are original Rembrandt paintings. The reason I'm talking about this certain instance is to give you an idea about what generative AI can do. Generative AI produces results which makes life convenient without really explaining you or the user of AI about how these processes work. There are, of course, training LLMs, and they are used to extract the right sort of data, which requires this use of massive farms and supercomputers. And as I mentioned, ChatGPT is just a tiny example of it. Because it relates to an LLM which was actually initially trained to predict the next word in a sentence and other auto completion tasks. So if you're using Binge, as in Bing, as your Internet Explorer mode, or even Google for that matter, these days it will search all the results and give you a more comprehensive search in the its first instance itself. So if you're looking for very specific queries, you wouldn't have to open all those search results, and it will give you in the initial part itself, which is, well, of course, AI generated because it has read all those results. So you have too many questions around AI generated content. Anything which is generated by AI. When you think of works like paintings, your assignments, research, any sort of research which is generated by AI in the form of a paper, in the form of a newspaper, anything which you use ChatGPT for, say, for writing something, or you use AI platforms to draw pictures. They are all subject matter of copyright. So I won't be talking a lot about copyright today because I have been told that you have studied copyright already, which is why I would want to delve into other areas of law which directly impacts AI. So of course, I mean, copyright is that really goes without saying. There is a lot of evidence about copyright protection being in place, so that if AI generated content even threatens, that sort of brand ownership of the brand of the owner itself, then they have to be able to give sufficient evidence on why and how they can get AI protection over that. I'm sorry, copyright protection over that AI generated work. And I mean, it's more of an ongoing process. Some countries have accepted AI generated works as authors, or AI as an author in a work. Most countries have still not accepted. Countries like USA, they continue rejecting the USPTO, the United States Patent and Trademark Office, or the US Copyright Office. They keep rejecting applications which are made when a painting is made by AI algorithms and training LLMs, because the simple factor is that for anything to be copyrighted, the author has to be a human being, which is the major point of contention where jurisdictions really differ, because their domestic laws can be different. Harmonization of laws in such a context is a difficult situation because it's again it's a developing thing. Every day as we speak, we have developments taking place which are difficult to keep up with, and that is what usually the problem with law is. Technology is way faster than law to keep up. And law is essentially just trying to chase the developments in technology. Similarly, you also have patenting and trademarks. Trademarks, again, I hope you have studied and you recall, are signs and symbols which are meant to give you source origination, which is meant to let you know that the where the product has come from. So if I'm looking at a book, or if I'm say looking at a book and it says Penguin Publishing House and it shows that penguin picture, then that's the logo, which is a trademark of the company, the publishing company. And it helps you in understanding that, all right, this book which I'm reading is actually from Penguin Publishing. It might be good, it might not be good, related to whatever your experience with that particular publishing house has been. So that's source identification, that's origination. It helps you in identifying where that product, or now that service, has come from. So for example, even NUSRL logo is a trademark, right? It helps you in understanding what sort of education services NUSRL is giving you. Uh, and it, depending on your experiences and other people's experiences, people have that sort of notions about NUSRL as an organization. Good, bad, whatever it is, there is a certain reputation attached. And that helps because you have a logo which you look at continuously to make up your mind. So that's trademarks for you. And then there are patents. Patent, both are correct pronunciation, US, UK, English. Um, Patents are usually uh, under the radar for this because AI solutions are notoriously very difficult to patent. And IP professionals and courts in ongoing conversations, they are constantly engaging with the question about what is and what is not patentable. Companies will need to consult with IP specialists to work out these paths, and that is where your role as a patent lawyer can really come in handy. Um, what is a patent? Um, I'm sure you must have heard of it. I mean, you are aware of the general idea of a patent. Um, it is an exclusive right which is granted for an invention, which is a product or a process that, in some way or the other, gives you a new way of doing something and offers you a technical solution to a problem. So what patents usually do, or at least what in principle they do, is that you offer a new solution to an existing problem, and that solution helps the society function better in some way or the other. It makes your life a little bit easier. So, patent protection is essentially meant for inventions which cannot be commercially made or used without the patent owner's consent. So, if I have come up with a new solution with a problem which we generally may be struggling with, for example, this pair of scissors, and if I was able to tell you that, look, I have come up with this pair of scissors which is different from an ordinary pair of scissors because I have added a certain element of safety to it, that it's that you just cannot cut your fingers with it. It has a new element to it which makes it safer to use, and therefore I will patent it. And what I mean by patent it is that I'll file for a patent application for this particular feature of the scissors, and then what I'll do is that I will enjoy monopoly over this patented scissors for 20 years. And then I'll have to eventually disclose that what is the certain feature in it. So, how patents usually work is that it works on a very quid pro quo function, which means is that I have to disclose the invention to the public so that people can make use of this invention after my monopoly rights are over. So it's more of a give and take sort of a situation happening here. Because in a patent application, what you do is that you tell them that that this is my patent information. And information can be very very complex. For example, take ChatGPT. If ChatGPT was made by an AI machine, and I have certain technical circuits in that machine, and then there are certain codes in it, and I don't want to tell people about it because obviously I will lose my monopoly. But then I also want to be sure that I can enjoy my patent protection over it, which is why I would then approach, a patent office in jurisdictions, and IPRs are territorial in nature, as you would have studied, I'm sure. And the reason then for me to go and look for a patent for it is because I want to make sure that at least for the initial 20 years, I get maximum monopoly on it. I can charge people for its services, and I can make profits out of it. So that's usually that sort of information which makes your product different from others, which is a very crucial part of your patent application, is known as patent information. And that is found in applications and is helped in granting patents. This information can include many things. It can include bibliographical data. It can include description of the invention. So sometimes in patent applications, say for example, again back to the safety scissors example, I will be required to give a pictorial description of the scissors, of the part of it, from the front side, back side, underside, everything, and to let the registrar know that what is the new thing in the scissors which makes it different. But then there will always be a question about why would patent applicants disclose such extensive information about their invention? And the reason is very simple. The reason is that the patent system balances exclusive rights granted to a patent holder over any invention which the obligation to publicly disclose information is there. So if you want to get protection over it, you have to disclose it. And that's the way how patent law works. Try to understand that it's very different from copyright and trademarks because of the subject matter. Trademarks is meant for symbols, for logos. For most of the times, they are 2D in nature, two-dimensional in nature, like a picture which I can see. Like so, for example, this book. This is just a trademark because it's 2D. You can see it. But there are other instances of trademarks now. There are smell marks, there are sound marks. Netflix to Doom is an example. Uh, Nokia ringtone is an example. There are now other non traditional forms of trademarks, which I'm sure you have studied in your classes. And those are all meant for source identification. And copyright, on the other hand, is meant for content, for works, songs, movies, books, and things like that. Patents come in when you're talking about a certain invention, a technical invention, something which you haven't seen before, something which is technical in nature, something which gives you a new solution, something which is new and novel. These are the important criteria for any patent to fulfill in. So you have to disclose that information because only then you get protection. That is how the system works. And the requirement that a patent applicant disclose information about their invention is extremely important for the continuous development of the technology. Um, this is again very important because you need to understand why patents are important from a more sociological perspective. Because what this information does is that it gives you a basis on which new technical solutions can be developed by other inventors. So, for instance, when somebody tried patenting this technology about a roller ball click gel pen, right? Yeah, you can see. What somebody must have done is that they would have patented this technology about the refill being inside a pen, and giving you a more smoother writing experience. um, and what this person did was that they must have disclosed the patent information about this refill in a pen, and then must have enjoyed monopoly for 20 years. Patents enjoy monopoly for 20 years, that's all. Now, everyone knows that this is a simpler way of writing, which is a refill in a pen. So that's technology which is now available to all. And now because it's available to all, inventors can further develop on it. So for example, the clicking button, right? This is a simple mechanism in which your pen experience has bettered, because now the chances of you losing the cap of the pen is far less because there is no cap. So it's more convenient. You don't have to worry about losing a part of the pen. That must also be an inventive step which somebody would have made, right? Just this click button, this is also an inventive step. uh, that somebody was able to better this pen by having this click thing, because they already knew that what the technology around a refill in a pen is like. And that was possible because patent law existed, because the inventor had to disclose what the refill in a pen technology would be like. So the point which I'm trying to make is that from a sociological perspective, and Murthy sir, by the way, loves giving this question in his exam. If if things aren't changed, um, why are patents important from an exclusive rights perspective? Why do people have to disclose their patent applications? What's the need to do so? How is it better for continuous development of society and technology? These are the reasons. Because when you disclose these sorts of information, people have a basis to further develop it. And when you are developing things, society is generally getting a better place to live in, because there are access to better things, there are access to better technological inventions. So it's therefore not very surprising that providing information for the public is a key task of IP offices. What kind of protection does a patent offer? Uh, it will give you certain number of years of protection, which means that if I am getting protection over this certain scissors, then that would last for 20 years, which means that for 20 years, nobody else in the competing industry can make a safety scissors like me, which means that I can inflate the prices of these scissors and I can sell it in the market at a price which I want, because there's nobody competing with me. So if I want to sell this pair of scissors for say 50,000 rupees, I can, because there is nobody in the market which is also selling a similar pair of scissors for 20 years. After 20 years, then, because I have already disclosed this information, my competitors can make similar technology scissors. And then obviously as competition laws set in, I don't know if you have studied competition laws, but what competition laws is that it regulates market prices, and it regulates competition amongst similar competing businesses and industries, so that no one company can enjoy monopoly. So that's the point I'm trying to make. That for 20 years, I can price the scissors as at whatever price I like. And then after 20 years, because my patent is my patent rights are no more exclusive, and this information is public to all, anyone can make scissors like this, and I'll then have to regulate the prices, because obviously customers have more choices now. If they want to buy it from another company, they can do so at a lesser price. So then I'll also bring down my price. That's how competition law works. Um, this is just a typical example of how a patent application looks like. Can anyone tell me what this could possibly be? Anyone? My, anyone? I don't know if if someone is answering in the chat box, or anyone.
Ma'am, can you repeat your question?
I'm trying to ask you that what do you think is the pattern invention, the application of which you can see on your screens right now. If you had to give a name, what would it be? It looks like a boat. It looks like a cycle. What does it look like to you? Is what I'm trying to ask. Anyone? So, this is a bicycle which was patented by this person called Louis Burbank. As you can see, the date of the application is 1900, and it's a very peculiar cycle because it allows you to exercise both your legs and your arms while cycling. And when you look at the patent application, the object of the invention is to provide means whereby one may enjoy with a bicycle exercise like that of rowing with a pair of sculls. Um, and it does look fun, of course, but I'm not really sure how the brakes work in this in this particular product. Similarly, there is another example of a very interesting patent application, and it also sort of makes me make my point about simple technical inventions. Not, I mean, in any, it doesn't have to be a technological breakthrough. What patent law also tells you is that you can, if you have a certain small inventive step which just makes an existing product a bit better, then you can also patent just that inventive step. So, for example, do you want to eat lesser? So, if that is your question or if that is your concern, then inventors like Dubus and Springfield have an answer for you because they patented this fork with a timer in 1995. Um, and what this timer does is that it, well, as the name suggests, it also tells you for how long have you been eating. And after an elapsed period of time, the fork, gives you a cue that another bite of food using that fork may be taken. And for any health enthusiasts in the class, you know that portion controlling is the real deal if you want to maintain your health, or if you're say looking to lose weight or whatever. Exercising, having a right diet, all of those things are important. um, so if you're somebody who overeats or who tends to overeat a lot, then these inventors are claiming that you can control your food intake to a healthy level by using this timed fork. So it's very interesting, and these two examples were actually mentioned in WIPO's more absurd patent applications. It's very interesting because WIPO one some more frequently than not they keep releasing a list of what they feel were the most absurd patent applications, things which will just blow your mind and which have been patented, because they're just interesting and they're new, not so much useful maybe. However, an important criteria of patent application is that it has to be technically useful as well. So you will have to show in your application that there is a certain utility angle to it. It has to be utilitarian in a sense that it helps your life. One important question about patent applications is that why do you need to file? When I say file, I'm referring to the whole process of applying for a patent. So you don't say that you're applying for a patent, you say in legal jargon that you're filing for a patent. And you say file because, unlike other subject matters, a patent application includes this whole loads of documents which are supported as your supporting documents to support, well, yeah, to support your application. So that's why you say that you're filing for a patent application. And whenever you go to an IP attorney or these big IP law firms who have very strong patent teams, Remfree Sagar, RK Diwan, for example, RK Diwan's Pune office does a lot of trademark filing work. Not sure how much of a patent filing work they do, but RK Diwan Delhi has a patent team. Remfree and Sagar Gurgaon, of course, they have one of the biggest IP, one of the bigger patent teams. And the thing with patents is that they are equally dominated by law students as they are by engineering students. So if you're somebody who is really interested, say, by how technical inventions work, by how science works, and sort of amalgamate that with law, then patent law is a very good opportunity for you. Or just practicing patent contracts. Anyhow, when you file, an IP attorney will tell you, or the first recommendation would be to do a patent search and then eventually file. A patent search is where you're looking at the database or the already existing database of patent applications, and then you're trying to see that whether your invention already exists or not. Is there somebody who has already applied for something similar in a patent application? Because if something similar already exists, then the chances of your application being rejected is significantly high. So you first check, and if there is nothing similar to your invention, then you apply or you file. And you file for many reasons, because it brings you good reputation. It helps you in proving useful for raising funds, for finding business partners. So if you would have seen Shark Tank, if you have seen some pitches in Shark Tank, you would have noticed that a good number of them try to sell off their pitch by saying that I have already applied for patent or protection over my product, or I have already received a patent protection. And when they say that they have already received a patent protection, you would have noticed that the faces of those so-called sharks, people who are looking to fund them, Vinita and all of those people, they eventually, I mean, their faces brighten up, because selling your product to a fundraising company by saying that I have already gotten patent protection over it sells your product better, because it means that you have already proved in front of a legitimate authorized personnel, which in this case would be the IP registry, that your product is new, your product is novel, it has a technical invention, all the checklists of what a patent is, um, and that your product is useful. So that helps in giving you a positive image. It helps in fundraising. It of course gives you exclusive rights. It gives you your return of investments. It gives you an opportunity to sell that invention. You must have seen this. Most people, when they come up with a breakthrough in a certain coding, they say that I'll patent it and then I'll sell it off, because you patent it, you provide attention, you attract attention to it, and then when there is significant demand over that technology, you sell it for a much higher price. So you get your return of investment. You can also possibly make a profit on it. I don't know if you have seen, but there's a very popular short video on Instagram, YouTube, and all sorts of social media where this person stops people and he just asks around that, "What do you do for your living?" And one day he stopped a person in a car. He was in this fancy car, and he asks the person in the car that, "What do you do for a living?" And he says that, "Nothing for now." And then the person asks that, "How do you have so much money?" And then the person in the car says that, "I was the one who invented contactless payment, which the technology around contactless payment. So, for example, you just tap your card, or you just tap your phone with NFC in it, and then you don't have to carry your cash or your card around, right?" So that contactless payment was a technology which was developed by this person, And now, till date, every time a contactless payment is done in the world, he gets a certain royalty rate out of it per that transaction, whatever, 0.5% of that transaction, whatever it is. So that's how then people make profit out of it in royalty rates and negotiating rates. It also helps them in attracting investment and in leveraging against third party patents. So that's patterns for you. And I know that I have only 4 minutes left. So I'll try to quickly also introduce you to the idea of a trade secret and to sort of also tell you that how can it, help in AI related inventions, if at all. Trade secrets are IP on, as the name suggests, on very confidential information. Um, what they do is that they are again meant for technical information, but they're also meant for information which is very sensitive in nature. And what makes information very sensitive is information which can give you a market monopoly and give you a certain advantage over your competitors. So, for example, pharmaceutical test data or designs or drawings or commercial information or say a certain list of suppliers and clients. So for example, a more relevant example for students would be, say, a list of all law firm HR emails. That is sensitive information for you because it can give you a competitive advantage over your peers, because now you have data, or you have a compiled information of all emails of HRs of law firms where you would potentially want to intern with and possibly get a job with. So instead of searching across multiple sites, you have a file already with you and you can email all of them. Would you want to share this file with everyone in your class? Most likely the answer would be no. You may want to share it with friends, but possibly not with everyone. You would try to gatekeep it as much as possible. So that could be an example of trade secrets. It's of course a very subjective example. There are many ifs and buts. At this point of time, the stay at stakes are the possibility of you getting an internship, but when stakes are much higher for companies where it involves millions of dollars, people can go to any extent to protect that secret. Examples of more popular trade secrets are the recipe behind soft drink companies, which they use, like Coca Cola or Pepsi. They have trade secret in it, which means that they do not share the secret of their recipe behind anyone with anyone, which gives you that certain taste. And that is why that market of soft drinks is dominated by very few companies: Coca Cola, Pepsi, Coke, and very, very few of them, which gives you similar kind of taste. And for actually people who are interested in it, they can, in fact, even differentiate between Coca Cola and Pepsi taste. For a lot of us, it may taste similar, but the more soft drinks fanatics can even differentiate between them. Their tastes are different. So that's as an example of trade secret. And how does it, excuse me, how does it help you in making the right call for AI related inventions? Even though trade secrets are important to protect AI related IP, there are various advantages and drawbacks of both patents and trade secrets. When you're looking at the decision whether to patent or to keep it as a trade secret, it gives a certain innovation which represents an important strategic decision for many companies. As an initial matter, the decision between patents and trade secrets um, is not always mutually exclusive, because in some instances a company can file a patent on the public facing part of a product, which can't really be kept as a trade secret because, well, it is not a secret, it has to be public facing. And at the same time, the company can also maintain as a trade secret certain manufacturing techniques or sorts of other innovations within the product which are not generally known. Then there are other strategies in which company can keep technology as a trade secret while also simultaneously applying for a patent protection by seeking non-publication of its patent application. And those are very, very peculiar instances because you'll have to showcase a lot of things in it. So in all of these scenarios, inventions, they can have trade secret protection for the period of that certain time. And then once that patent protection expires, that patent is issued, they can continue having trade secret protection over it. But again, what law does is that it ensures that it does not monopolistically give rights to a certain entity. So there are many factors which go about. So questions like, is the innovation likely to become generally known soon? How hard would it be for the company to determine that it's practicing your invention? How likely is it that you will have to withstand litigation? How quickly can the invention become obsolete? How quickly can it be commercialized? Um, does it does the invention comprise any sort of information which can be kept secret at all, and does it have to be there because it's a part of your business? So there are many questions around it for inventions. Yes, Hitesh, you just give me, I'm just taking a minute to wrap up. For inventions, you look at patents and you look at trade secrets. Um, I can give you a case study of Dabus. You can go back and have a look at it. It's a very interesting, technology which helps in inventing, and that itself is an artificial intelligence system which was created by this person called Stephen Thaler. It's made of two novel products. Uh, it made up two novel products. One was a food container which constructs using fractal geometry, and it helps in rapid heating. And there's also a flashing beacon for attracting attention in a sort of emergency. There are two different products which Dabus, and which in itself is an AI system, has created. Most countries have rejected it. Countries like South Africa have accepted it. So it's a more ongoing thing, and it's very interesting to see how what you can do about it. That's my email for you. If you want to get in touch with me, I'm happy to take any questions now. Questions do not have to be related to just this. You can ask me questions about IPR generally. You can ask me questions about, I don't know, anything. If you want to study overseas, if you want to make a career in IP, anything, I'm here. Uh, yes, that's all from my end. I'm happy to take questions now if there are any, or if you just want to message me on LinkedIn, or if you want to email me later on, you can do that too. My email is nsalar01 at the rate qub.ac.uk, and that's my LinkedIn. You can just scan the QR code. Sure, please go ahead.
This question is, how do companies protect trade secrets in AI sector?
What companies, so how a trade secret application usually works is that you don't have very specific legislations around trade secrets specifically. Very few countries have legislations around trade secret as specific subject matter. For instance, UK does. India does not necessarily have um, a specific trade secret legislation. They do it through contract law. So what they do is that they protect their trade secrets through having clauses in their contracts about sensitive information. So a clause would be there in the contract in which you would be asked to sign off that clause. Non-disclosure agreements, non-disclosure clauses, that's what you usually call. So for instance, if you join a law firm, you will be asked to sign a contract, and if it's a good contract, if it's a good law firm, someone who is very aggressive about protecting their IP, then they will make sure that the contract has a clause around you not using computer data, you not using information which the company gives you, you not using any clientele information which the company gives you. All of that would be there in the contract, and you'll have to sign it off. Which means that if you do anything against it, you will, of course, be legally sued by the company. Which is why then it becomes very interesting with AI, because Because what happened when ChatGPT started becoming very popular was that people started putting in sensitive meeting informations in the ChatGPT. They started putting in sensitive codes, very confidential codes in ChatGPT because they wanted to, you know, fix some bug in the code. So they wrote down the entire code in the ChatGPT box and they said that fix the bug for me. So it did fix the bug, but that came at the cost of a company employee, disclosing very sensitive code to ChatGPT. And obviously, once it goes to ChatGPT, it does not vanish. It's out there in the open. It's all part of its input, collection process, which means that somebody or the other has access to now the otherwise sensitive information which the company had asked you not to disclose. And that's how then AI and trade secrets, clash. How do companies use trade secrets? To be very fair, it's a very new area. Trade secrets generally, I mean, not trade secrets generally, but AI is, of course, a new area, and people are trying to use trade secrets in a sense that if that they have it in their clauses, they have it in their contracts. um, the legislations specifically don't have anything to say that there is trade secrets in AI, but there are movements going on where people are trying to add those amendments. But again, it's a very big question about whether you want to trade secret in AI or not, and if yes, then how will you do it? Most of the times, any invention by AI is stopped because a lot of jurisdictions say that an invention has to be made by a human being. It can't be made by AI. So that in itself is the wrong way to start. So very complex answers to it, but it also depends from subject matter to subject matter. Uh, yeah, I hope that answers. I'm happy to have a longer chat if you like.
We have two more questions. One of them is, how do different countries address the issue of patenting AI algorithms?
So different countries obviously have different ways of patenting it. Like I said, Dabus is one of the more common examples. Most jurisdictions like US, UK, they have rejected inventions which were made by Dabus, which in itself is an AI system, because these countries say that we can't get protection over it. But South Africa has said that we will give protection over it because it has more of a human element than an AI element. So there are different ways. Yes, to be very fair, most jurisdictions are still struggling. Even in UK this year, they were sure that I mean, they from the past 2 years they were trying to come to a conclusion over a policy which would help in AI generated content and copyright. They wanted all the stakeholders to sit down and talk about what rights and liabilities will be in question. But this year, in fact, 2 months ago only, the UK Patent Office and Trademark Copyright Office, they declared that all those talks have failed because stakeholders couldn't come to a mutually exclusive or mutual decision. So it's actually an ongoing thing. At the minute, most jurisdictions are trying to come to negotiations with stakeholders, and they're trying to draft policies which helps both the stakeholders. If these policies are made are they over a period of time they prove to be successful, they will be inculcated in the lawmaking process as well. But nothing comes within law at the start itself. There are always first negotiations, there are first soft law approaches, there are more policies first, and then it's come into law. So very few countries have reached that stage, to be very honest. um, yeah, that's, I hope that answers your question. Any other questions, please?
Yeah, we have another question about patent search websites. If there is
Yeah,
anything specific on the global level patents.
yeah. I will share it with you actually. So there is something called WIPO pattern scope. What WIPO pattern scope does is that it's a centralized access to searching international patent applications. I have put it in the chat box for you. What this website does is that it's a database. It gives you access to published patent applications. It gives you all the documents. So again, if this was a longer class, I would have. I mean, if I was teaching you this course, then I would have taken you. I usually dedicate one class to just walking you through the WIPO resources and to walk you through the patent scope website and how to operate that website. So this is the website for international applications. Countries have their own databases as well. So India also has their own registry database. Let me just type out that for you as well. It goes by the name of India IP Registry, and that's the official website of IP India. The Indian Patent Office in Mumbai gives out. They release their applications there as well. So yeah, if you would like to know more, feel free to email me or send me a LinkedIn message. Any more questions, or if this is the conclusion? I understand I'm in the way of your lunch and I don't want to keep you waiting for long.
Thank you, ma'am. We will now conclude this session. I would like to extend a heartfelt gratitude to you for sharing your deep knowledge and insights on patents and trade secrets. Your expertise and clarity in explaining such a complex and vital topic have been truly invaluable. A special thank you to the organizing team whose efforts behind the scenes have made this lecture possible and seamless. Once again,
Yeah.
thank you all for joining us. We look forward to seeing you at our future events.
Yeah, thank you, Mr. Mehto and Miss. I think Vartika was her name, who was the RA at the IPO for entertaining my last minute questions. Yes, thank you all, and please feel free to get in touch through email or through LinkedIn. Yeah, I think this is my sign to. This is my cue to. I can log out, right? Yeah. Okay. Thank you, Hiteshi. Thank you, everyone. Bye bye.